Hello and welcome. My name is Saba and I will be going through global laws resolving disputes in international law. In summary, I will be discussing what was the legal status of war during the League of Nations period and how effective was international law at this time in limiting states from going to war, as well as some international law components that are contained within Article 2, Part 4 of the United Nations Charter, as well as what are the exceptions to the prohibition on the use of force, and do these prohibitions apply to non-state actors such as terrorist organizations? In the aftermath of the First World War, the newly established League of Nations made a concerted attempt to restrict the use of force in international relations. The League of Nations was established in Geneva, Switzerland, and was active from 1920 to 1946. It was founded by 42 countries, and at its height, the League had 58 member countries. The League of Nations was administered by three main bodies: the Assembly, the Council, and the Secretariat. The Assembly composed of representatives from all member countries that met annually and discussed the priorities and budget of the organization. The Council was composed of four permanent members, which were Great Britain, France, Italy, and Japan, and several non-permanent members who were elected by the permanent members every 3 years. The Secretariat, led by a Secretary-General, monitored many of the humanitarian agencies. Now, there were a lot of political success related to the League of Nations and in preventing several small wars at the time. The League negotiated settlement to territorial disputes between Sweden and Finland, Poland and Lithuania, and Greece and Bulgaria. The League of Nations also successfully administered the former colonies of Germany and the Ottoman Empire, including Syria, until they were ready for independence. So, what was the legal status of war during the League of Nations period? The Covenant of the League of Nations was first published as a draft in 1919. The main article that determined the legal status of war during the main articles that determined the legal status of war during the League of Nations were Articles 10 to 17, which embodied what may be called the central and basic idea of the League: collective security, together with the various procedures for peaceful settlement of disputes. The most specific article was Article 10, where the members of the League undertake to respect and preserve, as against external aggression, the territorial integrity and existing political independence of all members of the League. In addition to that, Article 11 declared that any war or threat of war was a matter of concern to all members, whether directly affected or not. Every member had the right to demand that the question be considered by the Council, and if necessary, to insist on an immediate meeting. Article 12 also expanded upon all the members bound themselves to submit all serious disputes to peaceful settlement or to inquiry by the Council, and in no case to resort to war until these procedures had the time to lead to settlement. So, how effective was international law at this time in limiting states from going to war? We now know that the League of Nations has had various successful articles. However, it also has had its failures. In 1935, the invasion of Ethiopia by Italy was devastating, and earlier in 1932, Japan had also invaded Manchuria. In 1928, another treaty was established by the name of Kellogg-Briand Pact. The main components of this treaty were contained in their Articles 1 and 2, which contained two critical elements of prohibiting the use of force. First, states are not to have recourse to war to resolve international disputes. And second, states have an obligation to settle disputes exclusively by peaceful means. Though this pact was very well favored and very well written, it was not effective in preventing conflict such as the Japanese invasion of Manchuria, just like the League of Nations. They both, unfortunately, did not prevent conflicts, as well as other events leading to the outbreak of the Second World War. Progression of international law. Even though both of the Kellogg-Briand Pact and the League had their ups and downs, they significantly contributed to the success of international law. And in 1946, the League of Nations was formally abandoned and its powers and functions has been transferred to the United Nations. The Charter entered into force on the 24th October 1945 following ratification by the 5 permanent members of the United Nations Security Council, which are China, France, the Soviet Union, and the United Kingdom, as well as the United States, and a majority of other signatories. This is considered the official starting date of the United Nations for the first session of the General Assembly, representing all 51 initial members. With 193 parties, most countries have now ratified the Charter. In addition to this, the main article within the UN Charter is Article 2, Part 4, with relation to international law and the use of force and threats to use force against territorial integrity or political independence of any state. Indirect uses of force are also prohibited. In saying that, the definition of force is quite significant in this moment, where the UN Charter refers to the concept of force as opposed to war. This is significant because force encompasses a much broader range of conduct, and there is no requirement for a state to make a formal declaration of war for it be in breach of the prohibition on the use of force. So what are the exceptions to the prohibition on the use of force? The UN Charter provides for 3 exceptions to the prohibition on the use of force, and that's Article 51, the use of force in self-defense, Article 42, the use of force authorized by the United Nations Security Council, and Article 107, use of force against former enemy states, which is now obsolete. So, currently, only Articles 51 and 42 apply. With relation to Article 51, a great self-defense example would be the US's use of force against North Vietnam, Cambodia, and Laos in the name of the collective self-defense of South Vietnam, and the US's use of force against Nicaragua in the name of collective self-defense of El Salvador, Costa Rica, and Honduras, are exceptional in the use of the USA using force outside the victim state. Prohibition of force and non-state actors. Chapter 7 of Article 51 of the UN Charter outlines nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. Now the question as to whether or not this prohibition applies to non-state actors such as terrorist organizations. And the answer is collective self-defense. Collective self-defense was enshrined in Article 51 of the 1945 United Nations Charter. It refers to the right of all UN countries to use military force to defend other members' nations from attack if needed. For instance, the Australian forces exercised their right to collective self-defense of Iraq against ISIS that was actually based in Syria. This may sound complicated, but through collective self-defense, Australian forces were able to assist and aid Iraq as a form of self-defense against ISIS. International law has come a long way in the last 100 plus years. Though the League of Nations and the Kellogg-Briand Pact may not have prevented World War II, its creation was an event of decisive importance in the history of international law, subsequently then significantly contributing to the primary base of the United Nations Charter. Since the establishment of the United Charter in 1945, there have been ups and downs with international law and international relations, but not to the extent of another world war. This may be a clear indication that international law is an effective tool in managing the use of force against states.